No, I'm saying therefore, um, you say you don't want to touch personal laws, correct? And we've also put to you don't touch personal
I
law.
have not touched.
Then the argument is in a very limited
It
compass
is
of
about state
focus.
objections.
No, I'm saying well confined is can we in the Special Marriage Act, you say you don't want to touch personal laws. Read a
And
person you don't touch personal laws. Instead of the definition of a woman, the argument is in a very
That's all.
That's all.
limited
And
compass
leave
of
everything else
focus
for
and
focused.
some then confined is
in the future. That's
can
My
we in
lord,
the
my
Special
lord,
Marriage Act
just one aspect.
and no
read,
state intervention
a
inhibit
person-
your lordships.
May I then
instead
proceed?
of
My lord,
the
just
definition
one
of a
aspect.
I think
woman
One
and
minute.
man,
I think
That's
we'll
all.
now get
That's
back
all.
to
and
Mr.
leave
Rohit.
everything else
We'll get
for
back to Mr. Rohit.
some
My lord,
Now,
my lord,
good time in the future.
one second, just
my
one
lord,
second.
my lord,
One second.
just one
Here, I
aspect.
think
And
all of us on
no
the bench
state
have now
intervention
clarified.
inhibit your lordships.
May I then
Area,
proceed?
My lord,
the
just
limited
one
area or
aspect.
the area
Then
One
can-
we are going to
minute.
I think we'll now get back to
One
Mr. Rohitgi.
aspect.
We'll get back to Mr. Rohitgi.
My lord,
because
my
I
lord,
now
my lord,
clarify.
just
One second,
on
just
the
one
ambit
second.
of the laws.
One second.
My lords,
We have
briefly,
actually
just
all
on the
of us
ambit,
on
if
the
I may
bench
be
have now
permitted.
clarified.
My
Which
lords,
we
we have
have
challenged in
What is the
addition the
limited
other
area or
two
the area
secular
that we are going to
legislations,
explore in
and
this
many of
case?
us have, which
Let's
are the
hear Mr.
Foreign
Rohitgi on
Marriage
that,
Act
because I
and
My
the
lord,
now-
my lord,
Citizenship
just,
Act.
my lord,
And on the ambit
with
regard
regard
to
to
the
this.
Citizenship
My lord,
Act,
briefly,
my
just
lord,
on
the
the
word
ambit, if I may be
spouse has been
permitted.
used in 2015.
My
My
lords,
lords, we have challenged in
subsequent to
addition the
all
other
of these
two
other
secular
legislations.
legislations,
So
and many
if
of us
the
have,
doctrine of
which are
caste
the Foreign Marriage Act and the Citizenship
all that
Act.
is
My lord,
required,
that's
my lord,
very,
with
very
regard to
low-hanging
the
fruit, my lord.
Citizenship Act,
All that is
the
required
word
is to be
spouse
said
has been
that
used in
spouse means
2015.
See, one thing is
Subsequent
either
to all of these
we
other
confine it to
legislations.
this,
So
the debate
if
will
the
be
doctrine of
limited and we'll
casus
know whether we
omniscus
agree
is
with you or not
applied,
today.
all that is
If we don't
required
agree
is
with you,
very,
nothing
very
survives.
low-hanging fruit, my lord. So
All
all
those
that is
issues,
required
all
is
other
to be
issues don't
said
survive.
that spouse means spouse.
See, one thing is,
My lord,
confine it to this, if we the debate, suppose we agree with you, and we'll know
Yes,
whether
Lord.
we agree with you or not today. Then in
My-
what if we don't agree with you, nothing survives. The other thing survives will be
So-
all those issues,
second
all other
inning.
issues don't
My lord.
survive. Second, third, what time?
Look, the
If we-
Foreign
one-
Marriage
My lord,
Act is actually a
If
secular
we-
act,
suppose
which
we agree
is
with you.
really a
Yes,
takeoff
sir.
from the Special Marriage Act. So
Then in
that
what
would have to be
ramification, what nuance
included
the other
in
thing
this
survives
canvas.
will
Can
be
add
a
supplement
will
on
be a
Yes,
second
my lord,
inning.
it is only,
Second, third, what time?
look, the Foreign Marriage Act is actually a secular act, which is really
Let's
a
do this.
takeoff from
We
the
will,
Special
let's do
Marriage
this
Act.
now.
So that would
We'll
have to be
now start with
included
Mr.
in this
Rodgi's
canvas.
submission. Add supplement so that we can now look at
It is only-
we can now look at it with a sense of
I want to.
of a constitution bench hearing.
So that it's there.
Let's do this. We will,
Yes.
let's do this now.
We'll-
We'll now start with Mr. Rodgi's submission. So that we can now look at it, we can now look at it with a sense of
I want to.
of a constitution bench hearing.
The Rituparna Bora petition, there are petitioners who have anonymized themselves because they are coming from oppressed castes and communities. They are trans persons, irrespective of sexual orientation or gender identity. The relationships are taken place. So perhaps same-sex will not include them in that description. I will.
Yeah, therefore the emphasis was on personhood,
Person, same
on
person.
person.
Same person.
Aspect, we are also chosen family.
Consulting.
We want to say typical family. Can they be, like there is a live-in, can they be a chosen family, particularly when my natal family is hostile? These petitioners have faced hostility and violence from the natal family.
That's the perspective we wish to give.
A chosen family, both to take care of them and the accruing rights.
All right. Now, Mr. Rodgi, you can open now.
Can I? My lord, as well, I'm
Mr. Rodgi, now tell us about what's the time estimate for you?
My lord, all my time has been hijacked by people on my side.
No, but now we sort of, now the constitution bench begins as a constitution. Now confine yourself to this.
Only this.
My lord, your lordships,
Yes, only
while,
this.
my lord, your lordships, while fixing the remit of the matter also, your lordship said that we would hear the side. My lord, would your lordships like to consider hearing us? Your lordships have fixed the remits.
All right. Yes, certainly, Mr. Yes, Mr. Mr. Mehta. Certainly. Yes, Solicitor.
Lord, and this is, my lord, I must, my lord, make it, my lord, I in fact achieved an impossible thing today, my lord, making my lord the Chief Justice angry. Few people have done in past, but I am not in very excellent company, my lord, I must confess that. Lord, first of all, the question really, my lord, we are misdirecting the question. The question is not right of equality, right of dignity, or right of privacy of persons who belong to LGBTQ community. That is first. The question is right of conferment of a socio-legal status and whether that can be done by judicial adjudication. But so far as, my lord, kindly give me 15 minutes, my lord, to give the chronological events. But there was no law governing, my lord, the rights and other rights and other, my lord, immunities to the LGBTQ community, my lord. Nalsar judgment came, thereafter Navtej Johar came. Lord, now kindly see, my lord, my affidavit. I am not on the merits of the matter, my lord. On merits, I have different arguments. Please see the Transgender Act. Most of the arguments, my lord, are covered. There is no legal lacuna. There is a statutory framework and there is a conscious omission by the statute. My lord, in my IA, my lord, I have annexed the small act. My lord, this is 2019 Act after Navtej Johar.
I'm not talking about transgenders here. Lord, my
Your
case
Lordship
is
have
not on transgenders. My case is not on
My
transgender.
lord, my learned friend may allow me now. My lord, I never interrupted him.
But then, sir, I am on my legs. I want to finish my thing. Lord.
My lord, he has not seen the act. Otherwise, he would not have said this.
Wait. We have permitted your side to.
I know that.
Just open and
To
give
get a
us a.
perspective.
No,
Article,
I am not saying no,
you
Lord.
couldn't plead violation of
No,
article.
I'm not complaining. I want to get on with
You
it.
also get a right to set forth the contours and we may be able to put some.
I appreciate. No, I'm not.
How we are limiting what we propose to limit. So that
Lordship.
then, unless you know what he has to say, how.
Lordship,
Lord, this is of course, my lord, subject to my first respectful submission about the maintainability. But my lord, just I'm assisting your lordships on this. Lord, this comes after your lordship's judgment of 2017, Navtej Johar judgment. Lord, please see, my lord, so that my learned friend rest assured, page 34. Your lordships have that, my lord, my application.
The act actually. We've got
Act, your lordships have the act, my lord. Kindly see section 2. I'll not read all sections, my lord, some of the sections. Appropriate governments, your lordship can skip. Establishment, defined. Family, defined. Inclusive education, defined. Institution, defined. Please come to 2K. Transgender person means a person whose gender does not match with the gender assigned to that person at birth and includes trans man or trans woman, within bracket, whether or not such person has undergone sex reassignment surgery or hormone therapy or laser therapy and such other therapy, bracket over, persons with intersex variations, gender queer and person having such socio-cultural identities as so-and-so, so-and-so, so-and-so. Correct, my lords? Your lordships concern freedom of choosing sexual orientation. No objection, my lord, cannot have any objection. That's my lord's judgment. Freedom of privacy, no objection, act take care. Discrimination, there cannot be, the act takes care. I'll, my lord, show to your lordships. The limited question is conferment of a socio-legal status and whether that can be done by judicial adjudication, and I'll come to special marriage act. Lord, now please see prohibition against discrimination. Lord, all arguments that we are not getting this, we are not getting treatment, we are not getting, Lord, please see this. No person or establishment shall discriminate against transgender person on any of the following grounds, namely the denial or discontinuation of unfair treatment in educational establishments and services thereof. And transgender here means LGBTQ+, not, my lord, transgender as we colloquially or, my lord, conventionally understand. The unfair treatment in or in relation to employment or occupation, the denial of or termination from employment or occupation, the denial or discontinuation of unfair treatment in healthcare services, the denial or discontinuation of or unfair treatment with regard to access to or provisions of enjoyment or use of any goods, accommodation, service, facility, benefit, privilege, or appropriate or opportunity dedicated to the use of general public or customary available to the public, denial or discontinuation of unfair treatment with regard to right of movement, denial or so-and-so unfair treatment with regard to right to reside, purchase, rent, or otherwise occupy any property. These are all criminal offenses if there is a denial. Denial of access to removal from unfair treatment in government or private establishment in whose care or custody a transgender person is, then recognition of identity of transgender persons. Recognition of a transgender person shall have a right to be recognized as such in accordance with the provisions of this act. Right to dignity, right to personhood, as my Lord, the Chief Justice said. A person recognized as transgender under subsection 1 shall have a right to self-perceived gender identity. Application for certificate of identity. My Lord, statutory certification. There are changes which take place, my Lord, because of hormonal therapy, other therapies, operation, etc. My Lord, there is a concept of fluid gender. Sometimes a person is male, for a few days he is female, etc., etc. My Lord, let's not go into it. That's on the marriage, and we have much to say on that. Change in gender. After the issue of certificate under subsection 1 of section 6, if a transgender person undergoes surgery to change gender, either as a male or female, such person may make an application, my Lord, then he gets a new certificate. Obligation of the appropriate government. There are statutory obligations, either central government or the state government, as the case may be, to take steps to secure full and effective participation of transgender persons and their inclusion in the society. The appropriate government shall take such welfare measures as may be prescribed to protect the rights and interests of transgender persons and facilitate their access to welfare schemes framed by that government. Appropriate government shall formulate welfare schemes and programs which are transgender sensitive, non-stigmatizing and non-discriminatory. Appropriate government shall take steps for the rescue, protection and rehabilitation of transgender persons, etc., etc. Then, my Lord, obligations of establishments and other persons. Lord, there is a provision for a reservation for transgender persons. It's not, my Lord, right now, nobody is arguing the question of dignity, respect, privacy, etc. Right to choose one's sexual orientation. The definition is widely worded. Any deviation from the normal sexual my Lord, orientation is protected under 2K. And, my Lord, rights are given, and any discrimination is criminally prosecutable. Right now, the limited question is, can by a judicial adjudication process, this honorable court create a institution of marriage for the simple reason, Lord, whether we like it or not, whether they give it up or not, whether, my Lord, your court would go into it or not, it necessarily affects personal laws. Lord, Hindu Marriage Act is a codified personal law. Islam has their own personal law. Part of it is not codified. Hindu law also, part of it is not.
Getting into it, Solicitor, we said
Only a minute.
to them that so far as personal laws are concerned, we are not at present getting into that arena at all.
That's not the point. Somebody who is Hindu, who is not here, can come and say that, why did you not give me the same treatment? I want to be Hindu. I want to marry under the Hindu Marriage Act. And if you give benefit,
But we are not getting into it.
We are
Why?
getting into it. So then where is
your lordship will have to. Right now, your lordship don't have that argument.
We of
There's no
course not.
compulsion, we
No,
must get it.
Only a minute. Like, can I?
You don't have to decide the broader in order to decide the much more restricted
That's what he
arena.
said.
Another aspect. And which I that confining the remits, my Lord, I have something to say, my Lord. Lord, your lordships would have Hindus, Muslims, everyone, whether your lordships go into or not, everyone will be affected, and therefore the central government very respectfully but specifically, my Lord, prays that states will have to be heard.
How many times will you
Yes,
say
that's
the
the
same
question
thing?
we are trying to pose to Solicitor. If we are not touching the person, it's like saying that you must touch personal law. We don't want to touch personal law. We don't want to touch personal law, then why state should be heard? We are confining our remit at the moment only to one issue. So for that issue, whatever has to be heard
No,
is
my
only
lord.
for that issue, which is
Marriage,
under the special, completed, then you may answer. Under the Special Marriage Act, can we read it in a manner that it is a person? That's all. We are saying we are not going into it. So why should there be a compulsion of the court? You must go into it.
Mr. Solicitor, can
That's
you
it.
give an example of what you're trying to argue? Because if the remit is being defined in this manner, how do you say that this has some other repercussions?
Yes,
If you are-
Lord, one Mr. A, he is Hindu. He wants to continue as a Hindu. He wants to get married under the Hindu Marriage Act. He wants to undergo the,
We're not going to address
We are
that at all.
saying we are
right now.
not, we are not rejecting or accepting. We are saying we are not doing it at the
my
moment.
lord, we are then begging the question, my lord,
Maybe.
No.
to reach somewhere, we are, my lord, short circuiting the issue, my lord. That's, kindly, my lord, allow me. Kindly let me, my lord, I am for the first time begging that I may be heard.
To create something which we are not doing, and then you say.
I'm
you
just-
can't.
I am obliged.
Understand what is that you are saying? We are saying we have confined them. They may have opened a very wide chapter. We said, no, we don't want to get into that wide area. We don't want to get. Today we are only deciding this A issue. We are not touching other issue. Nobody is being prejudiced because we are neither rejecting it nor accepting it. Then we can't be compelled to hear everything else.
No, nobody is compelling, my lord. At least on our side, we are saying your lordship should not hear.
No.
We are not
You're
compelling.
saying, but you are saying, don't hear this alone, hear everything. Or hear.
No, I am saying don't hear it, my lord. I am
You're
not.
saying, don't hear it at
I
all.
am saying let the parliament hear it, my lord.
That's right, but therefore, we are trying to steer a middle course, which is that we don't want to
Lord,
first say
it-
that, well, we will decide
Lord,
everything.
when we are
And
deciding
then be
fate of,
and then be confronted with this argument.
Is opening, but
it has several windows have opened.
in the window, you'll have to open the entire door, so don't do it.
I would, my lord, kindly on the lighter side and don't take otherwise. Several windows have already opened. Now they are trying to open the door. And I am saying that you will have to ultimately open your entire house.
Mr.
As an
Solicitor,
example, the question is whether those
He is relying on those windows which have opened.
these windows have got sufficient breeze inside or not is the question.
Now,
And-
another aspect.
And those windows are willy-nilly going to open whatever we decide, because society is not dependent on.
Lord, I
on
must, my lord,
legal
say as a
arguments.
citizen.
Windows have opened up.
No, no, my lord, I'm saying as a citizen, I'm not saying yes or no. Societal relations, acceptance of any relationship in the society is never dependent either on legislation or on judgments. It comes only from within. Let us accept it, whether we like to accept it or not.
Widows will not.
But leave it at that. That's, my lord, more on my lord, other philosophical aspects. Your lordships are persuaded to take up special marriage act, possibly, my lord, on the ground that in one of the section, the word used is spouse. My lord, my respectful submission is this, and kindly, a person, my lord, not a spouse. My lord, my respectful submission is this, and kindly, my lord, examine this correctly, a little, my lord, closely. Even special marriage act, and I will show, my lord, if I have to, my lord, at the a subsequent stage. The legislative intent of the legislature throughout has been a relationship between a biological male and a biological female, including special marriage act.
But Mr. Solicitor,
Number one,
there's a very important value judgment which you are making, that the very notion of a biological man is absolute, or that a notion of a biological woman is also an absolute notion,
Never change.
which is incorrect.
The only,
No.
biological man means biological man. It's not a question of notion.
Positives of rights.
Yes, of course it is.
None of us.
There is no absolute concept of a man or an absolute concept of a woman at all. That's the
Lord,
whole
I am-
argument in a broader constitution.
Biological man, my lord, means man only. It means, my lord, biological man. It's
Biological
not a
man is
matter
not a
of
definition
notion.
of what your genitals are. It's far more complex. That's the point.
We stop having rights if we are not a biological.
So even when the Special Marriage Act says man and woman, the very notion of a man and a notion of a woman is not an absolute,
Kindly,
based on what genitals you have.
Lord, biological man means genitals you have. Lord, I didn't want to use that expression.
That's a point of view.
Lord, another thing, for man, irrespective of other attributes than the genitals, there are separate age limits prescribed. Lord, what are we doing?
No, this-
No, that's not an argument. That's not an argument.
Or we said it is not a mandatory thing that the whole society must accept something. Changes are always coming.
But your lordships will have to examine whether marriage is a fundamental right. Right to marry, divorce the law is a fundamental right.
That's what I want to establish, no?
Lord, only a minute,
What
only a
else do you
minute,
want to
Lord,
establish?
only a minute.
Seeking to confine.
Lord, I know my difficulties, Lord. I know my difficulties, but I am still discharging my duty. Lord, there are several acts. If the notion is treated to be a guiding factor to decide man or a woman, then I will show several acts which your lordships would unintentionally make non-workable. I may have, my lord, genital of a man, but if I am otherwise a female, my lord, as my lord possibly trying to be suggested, then, my lord, how would I be treated under the criminal procedure code? As a woman, my lord, can I be called?
Does he say?
For 160 statement after a particular hour, I may say that this is only a notion. I may have a biological genitals of a man, but now I am a woman. My lord, there are several issues, my lord, which have to be gone into, better they go into, be gone into by the parliament. And your lordships, my lord, kindly appreciate. But the parliament, we have good, eminent parliamentarians on both sides. And I can say this based only on my reading. My lord, parliamentary committees are not, my lord, acting the way in which, my lord, we see parliaments functioning. Parliament committees have all parties as members.
The lighter side, they say that real work is done in the parliamentary subcommittee.
Yes, yes. My lord, they call witnesses, they call expert witnesses,
Mr. Solicitor,
they
you're
call
right.
stakeholders,
Mr.
they
Solicitor, you're
decide.
right. We have, both Justice Kaul and I, we have engaged with the department-related parliamentary committee. I chair the E-committee, Justice Kaul chairs NALSA. We have engaged extensively with the parliamentary committee. In fact, part of the reasons why we have this huge support now for the E-committee is because of the
I know, I'm
bipartisan
aware of.
support
In
which
a
the
different
parliamentary committee
capacity,
gave
I'm
our
aware.
work.
Right. But see,
No, my lord, it's not that, my lord. There are certain issues, my lord, which are better left to the discretion
That's
of the
of course.
parliament. Your lordship's, my lord, concern, the government shares.
I have a point.
No discrimination, no breach of privacy, right of choosing one sexual, my lord, orientation, everything is taken care of.
Mr. Solicitor, you are underestimating the impact which your argument is having on us. Don't underestimate the impact which your submissions are having on us. And now it's our turn now to put those problems to Mr.
My lord,
Rodwin.
another aspect, my lord, another aspect.
We know where we are trying to
confined
find.
it.
We are also
I'm
trying to
fully
see where we can
confident,
draw the
my lord, I'm
lines.
fully confident. I'm fully confident. Only a minute more, only a minute more.
You may continue. I'm only saying they came with a broader canvas, much broader canvas. We are saying we are unwilling to go into the broader canvas. We are not willing to go into the broader canvas. We are not willing to go into personal laws issues. We are not willing to go into ABCD. Therefore, they have agreed to, for the time being, confine it only to the aspect which we are willing to rule on. And it cannot be said we must rule on everything. We are only willing to rule on that aspect. If that is the only remit which we are willing to consider, then actually their arguments or your arguments, you may have arguments whether it can be done under this act or not, whether even what is being sought to be canvassed by them should be left to the legislature to consider whether they would like to get into it. But the remit or the contours of the argument will thus have to be restricted only to the extent we are willing to consider the issue. It can't go.
I'll just
That's all.
give an example why I'm saying this. I'm just giving an
And
example.
it is
Live
still open to you to argue in response that don't go into even this limited
Yes,
remit.
yes,
That is again.
I'm obliged, I'm obliged.
Yeah, more
Lord,
than
what
open
has
to
happened
hearing.
is,
There's no
what has
difference.
happened is this. In Navtej Johar, when the limited question was decriminalization of, Lord, section 3, X mentioned in 377, the central government very carefully filed an affidavit that we leave it to the wisdom of the court. We are not, but there we did say in no uncertain terms and recorded by your lordships that this is not an issue where we were even remotely touching about other issues of marriage, etc., etc. But as my lords have said, the window of marriage did open there. Now, today your lordships may not go into the question of personal laws, but the window of that personal law will open. Lord, ultimately, your lordships are dealing with
Mr.
a
Solicitor, We cannot ever bind future generations after we are
That's
gone.
exactly
and
my
after our
submission.
deeds are dusted and done.
Lord, that's my,
That's the task for the future generations.
Lord, that's from,
Whether
that's
it's
my,
the legislature or the court, I mean, we leave it open to
Lord, that's
future
my,
generations to run
I'm
the
saying,
country with the
no,
sense of
I'm not
maturity.
saying your lordship would bind. Your lordship would never bind. That's the majesty of the court. But your lordship's not going it right now and giving some, Lord, considering giving some relief would not mean that your lordships have never gone. That would, my lord, open another. That's all okay, my lord. That's okay. But ultimately, my lord, your lordship will have to consider, but this even Special Marriage Act does not prohibit. And entry 5 concurrent list is agnostic. It's not on personal law. It's a law of marriage. It's not Hindu marriage, Parsi marriage, or Muslim marriage. It's a law of marriage. It's their right to legalize, not to legalize, provide for many things, etc., etc. And therefore, my lord, again, I am reiterating that my preliminary application, and there is a reason why I am repeatedly reiterating. My preliminary objection be taken up first, and your lordships may issue notice, my lord, to all the states. I'm reiterating that request with a purpose, my lord, with an intent.
All right, we'll reflect on it at lunch and we'll take a call. Certainly we'll, now that you.
May I have 2 minutes, please?
Yes, Mr.
To
Dedi.
add, Mills. Adopting everything which my learned solicitor says, Mills. About the canvas, Mills. So far as the Special Marriage Act is concerned, even if not this court, I'm assuming Milord, the lordships are inclined to update it or read in something in this act, Milord, so as to accommodate Milord, the interests of the petitioner. Even then, Milord, first of all, the preliminary issue would be whether, my lords, the heterosexual unions with whom they are seeking equality. Mr. Rotegi himself said that if your lordship holds that they are equal, then the issue of reading in, etc. arises, my lords. Without first going into that question of equality, because it is going to be our strong submission, my lord, that there is no equality, my lords. It is one thing that they claim civil rights of different kind, with all sorts of consequences. Many countries, my lord, have had separate, my lord, enactments giving them certain recognition, certain rights. Even in UK, my lord, first there was a law enacted which gave them separately a right, and subsequently, my lord, this equality was granted by legislation. And therefore, my lords, the first and foremost question is, would this court be holding, Lord, because earlier in Navtej, your lordships never granted absolute equality, my lord, with heterosexual union. That was not the issue at all. So the lordships have not educated us that no judgment should be read, will not dehorse the issues which had arisen in that case. In that case, not the only issue was about the decriminalization, section 377, which in that context, your lordship made certain observations. Yes, as lawyers, my lord, we are entitled to rely on those observations and try to build further, my lords. But then that is not a final authority, my lord, for complete equality between the two kind of relations. One relation which has been existing, my lord, since time immemorial. Enormous continuity for heterosexual union. And that heterosexual union, my lord, as the lordship knows, is responsible for the perpetuation, the very existence of the human race, its perpetuation. Without it, my lord, the society itself will not live. The nations will not be there. But the other relationship, merely because there is love, affection, and concern and care, etc., that's just one part of the heterosexual union. That's not the core of the relationship. The very heterosexual union, this marriage amongst them, this institution is not the gift of law. It has been existing since Rig Vedas, lords. And it's continued. The Manusmriti continued, lords. And all religions, lord, so basically, lord, these marriages have evolved over thousands of years, lords, and are based on usage, custom, religion, etc. And the core purpose was to perpetuate the human race. Without it, this relationship, lord, it can't exist. You may have n number of other kind of relationship. Malanipton refers to group marriages, polyamorous marriages, and so many things are existing, and this same-sex is not a new phenomenon. It had been existing earlier, and they never claimed equality. They were never given equality. That's a very important aspect. Go as far back as in history, they have existed, but not on an equal level. Today, under the Constitution, it is one thing that they want to claim. The question is, therefore, what I'm trying to say is that this fundamental question, are they absolutely equal? Once your lordship comes to that conclusion that they are, then and then alone the question will be, do we read it in this act itself without any necessity of declaring any enactment ultra vires and so on, Lords. And the second aspect is, Lords, that even under the Special Marriage Act, there are two aspects. If your lordship looks at one section, it's 19. On 19, section 19,
Yes.
the two relations, the two unions are different, at different pedestal. Section 19, the professes the Hindu.
Where are you reading, Mr.? 19.
I'm sorry, miss. Section 19.
Go ahead.
The marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh, or Jain religions shall be deemed to effect his severance from such family. So there is a consequence on the personal law. Well, that of course will be, they can say that it's my choice, I'm willing to.
Right, exactly.
That's fine.
This 21.
But then this,
21A follows. 21A follows. Not just 19, 21A. Amended in. PC.
now further, degree of prohibited relationship. These are all, my lord, reflections of the personal law.
Yes.
What I wish to say, my lord, is that marriage amongst heterosexuals or the heterosexual union is not a gift of any of these laws. These laws are only regulating the long-standing relationship which has been existing in our society. They are only regulatory. Now kindly have section 4.
Subsection 6. It talks of biological man and biological woman. 4C.
Now, kindly have 4B first. Neither party, and in fact in A, the expression spouse itself is indicative of an heterosexual relation. That's of course a question of submission on merit. B, neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind, though capable of giving a valid consent has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children.
It talks of
So the procreation of children and the perpetuation of the society, my lord, and the race and the nation is an intrinsic idea, my lord, spelled out in this. Therefore, that question will have to be decided first. And even if you decide it is equal, whether your lordship can still, my lord, read in, change all these provisions so as to accommodate, would be a submission on merit that is not possible even on merits, even if your lordship holds that they are equal. And then see, the male has completed the age of 21 years and the female the age of 18 years. Now, how can, my lord, the question of man and women doesn't arise?
It's to be biological man and biological.
Yes.
Now, kindly have section 12.
So the way these
These are all arguments on merit.
It's on the merits, but I'm just briefly, not cursorily taking your lordship's.
No, this is an argument saying that don't do this, as the solicitor said, because it has various other ramifications. Even under the Special Marriage Act, don't do it.
With respect, I'm saying something. I appreciate the fault from my lord. No, I'm saying something else. I'm saying first because of the historical submission which I made, because of these provisions, etc., and because of the fact that under this act, my lord, the states are empowered to make rules. Therefore, my lord, the states are absolutely essential party, necessary party, my lord, and no adjudication should be done without, my lord, issuing notices and pleading the states.
All right, we'll consider that.
Particularly, we have moved an application and I have not got an opportunity, so I must be, my application should be allowed, my lord, and given an opportunity. My lord. Thousands
Yes,
of
Mr.
people.
Bill.
2 minutes, only 2 minutes. Well, it's, at least some of us on this side, at least for speaking for myself, believe in the autonomy of the individual. Well, and I think people are entitled to have a relationship of whatever kind, whether it's the same sex or not. Well, I think that needs to be celebrated because that's the way society is moving forward. But having said that, Mullahs, assuming your lordships were to say it is a valid marriage, it's fair, Mullahs, your lordships can say that. Now, Mullahs, supposing the marriage breaks down, they've adopted a child, what's going to happen? Who's going to be the father? Who's going to be the tenant? Under procedural criminal law, Mullahs, who is the woman? Who will be maintenance? These are very, very serious societal consequences of that declaration. Either you take it as a whole or don't take it at all. I'm not averse to either. But if you do it piecemeal, it'll create more problems for that unity, for that union, for those two people, whether they're women or they are. In other legislations, when this has been done, if you look at the legislations around the world, they actually reform all the other laws in tandem with it. If you do it piecemeal, you will actually be hurting that very community. And that's very dangerous. I am all for it personally, but I'm not in this fashion.
So are you saying do everything?
Either you do everything or you do nothing. But if you do it piecemeal, you're going to hurt that union.
You are representing which state? Sorry.
Well, I'm not representing anybody. In fact, I need not even argue because your lordships are leaving out personal law for Jamaat. So I need not even argue. But I'm just,
No, I just
I
wanted
think
to
an
know,
officer of the
just to
court.
appreciate
I
the
just-
submission, I wanted to know which is the group you represent, if you're not representing.
I'm sorry.
Which is the group you represent? Which is the
The
stakeholder?
Jamaat, Malaj. Jamaat Ulama. Therefore, Malaj, I am out of it, really, because your lordships have clarified it. I don't have to be here. But Malaj, I want to, no, just as having practiced here for so many years, I need to.
Yes, yes.
Yes, Malaj, these are very,
Wanted to be-
very complex, serious issues. If you decide it piecemeal, it's going to have huge ramifications. There'll be ghettoization. Imagine the impact in a village.
Mr. Sibbal, what we can do is that
Yeah.
at the latter part of the arguments, we'd like you to assist the court for about half an hour or so. Please do.
Deeply.
We come back.
To just take.
May I have your lordship
response to
attention?
what has biological, just.
There
are certain
other organizations. For
example.
Look, we can't be hearing everybody to open their cases. What we do is now we've got a broad understanding of where the rival viewpoints are. We'll come back after lunch and now begin with Mr. Rohatgi's
Very well.
submission. I
That's
think.
all.
your
The only thing what we
attention.
wanted to say is, not on the merits, but Lord, Bharatiya Sant Samiti, the Hindu chain. I'm not on that, I'm in the
So,
institution of marriage,
now just one
on the
thing
society.
on the logistics, Mr. Rohatgi.
Lord, I will finish by 4.
By 4 o'clock.
Yes,
Now, once you have covered this ground,
yes,
we take it that the others will only make short supplementing submissions.
yes.
Who will be leading? Dr. Singhvi, how long?
Dr. Singhvi, Mr. Kirpal wants to say.
Mr.
Dr.
Kirpal.
Singhvi, then Mr. Vishwanathan.
So, my lord, I'll just submit.
Give us a small.
Just give us a list of the order, set
I'll
out the orders,
open.
that we can call out the names
Certainly.
one after the other. And we will
What
take it
we would
that
propose, my-
maybe all of you should be able to conclude by Thursday.
Very well, my
So
lord.
that we'll give you until the end of
Yes,
Thursday
Lord, I
for the
think
entire
that
this
that
side.
would be sufficient.
And the following week, we can, Malaj.
Even that I feel, once you have addressed.
The others will have very short submissions.
Supplementing. I don't know
Yes.
if you finish today, how much supplementary can there be?
Not much.
Lord, I will place the relevant judgments which will establish according to me that we have a fundamental right, my Lord, to a marriage.
So
and it
perhaps
is so
Thursday
difficult.
afternoon, the others
Yes.
can start. I think Thursday afternoon, the rest of the can start.
And I'll get my choice.
Highly obliged.
But I would.
May I have a turn for a
Lord,
few
your
minutes?
lordships
after?
are rejecting my application.
Mr. Solicitor, Mr. Attorney General?
Yeah, after lunch, a few minutes,
Yes,
the lordship's
after
time.
lunch.
Very good.
We're highly obliged.